Welcome to Ballantyne Law, clear, practical legal advice that works. Hi, I'm James Ballantyne and I'm the Managing Director here at Ballantyne Law, and I'm speaking today to Ali, who is a Senior Solicitor and who runs our Estates Division. Hi Ali.
Hi.
We're going to talk today about a concept known as capacity, and in particular testamentary capacity. So Ali, what is capacity?
So capacity, and especially testamentary capacity, is quite a tricky area. It's not necessarily a legal test and it's not necessarily simply a medical test either. It's an intersection of both.
Okay. So I mentioned testamentary capacity. What does that mean?
So testamentary capacity specifically is the ability to make a will.
Okay. And a will that deals with your estate after you've died. And obviously we want to be able to have people know what they're doing and understand what they're doing. So Ali, who gets to decide who has capacity?
So firstly, if a will has been executed and it's a valid binding will on the face of it, it can be assumed that that person had testamentary capacity. Okay. However, if there's evidence to suggest that the person did not have testamentary capacity at the time, then ultimately it is for the court to decide.
And what sort of things might suggest that someone doesn't have testamentary capacity?
So it might be a matter of things such as their age, their health at the time, whether they might have Alzheimer's or dementia, that sort of thing.
So how does a court determine, without going into the practical realities of court hearings, is there a test that the court would apply when working out testamentary capacity?
There's a famous English case called Banks and Goodfellow, which is the basis for how we go about establishing, or how the court goes about establishing testamentary capacity. So there are 4 key elements to the Banks and Goodfellow test. Those are that the person must understand the nature and the effect of making a will. They must understand the extent of their estate and what their estate comprises. They must comprehend and appreciate the claims and against their estate and the claims that they should give effect to, and they must not be affected by any disorder of the mind which would otherwise influence their decision.
About making a will. Okay. So I understand that there's something else or another issue around will making known as knowledge and approval. And, that's different to testamentary capacity.
It is. So capacity is one thing, and that relates to obviously the mental ability to form a will at the before you're passing. Knowledge and approval is something completely separate. So that is whether the testator knew and approved of the contents of the will.
So someone could have testamentary capacity, but if they sign a piece of paper that they hadn't read and didn't know what it was that was turned out to be a will, they might meet the testamentary capacity test, but they don't meet the knowledge and approval test.
Exactly.
You mentioned with testamentary capacity there's a presumption about wills that are rational on their face and that have been properly executed. Does that same presumption apply to the knowledge and approval issue?
Yeah, it does.
Yep. And when will the court look into these issues about knowledge and approval?
So again, as I touched on earlier, if there's a validly executed will, then we can presume firstly that the testator knew and approved of the contents of the will, and secondly that they had the testamentary capacity required to make that will. So should somebody, however, come along with evidence to the contrary, then...
So suspicious circumstances that might exist, and there's lots of those, aren't there? There's things like if someone is, a friend or a relative brings their loved one into a
and that's often
and gives the instructions on their behalf.
Exactly.
Or if someone is suffering from an illness or there's other suspicious issues that arise, that can bring the court into the matter to prove that there was knowledge and approval as well.
Yeah, absolutely.
My understanding of capacity and testamentary capacity and different types of capacity is that sometimes people who might have an issue with capacity can be really good, and sometimes they can be very poor in terms of communication and understanding. When, in relation to testamentary capacity, when is the test applicable? Is it for a period of time or all the time?
Yeah, no, it's a good question. So, I mean, the answer is really whether the person had capacity to give the instructions at the time that the will was formulated. So, as you said, we all have, good and bad days, and sometimes with people such as those that may have Alzheimer's, they have better times than others throughout the day.
So what kind of role can we play as lawyers in this scenario? If we're seeing clients that might be extremely old or unwell or suffering from a cognitive impairment like Alzheimer's or something similar, does that mean, sorry, we can't help you, you don't have testamentary capacity?
No, but I think that the most important thing for us as lawyers is that when we do encounter those red flags or risks, we need to be aware of them firstly and take really good file notes as they may become relevant one day to a court hearing, but also that we can go about still executing a very valid and binding will for that person if they have the capacity to give us those instructions, then we need to follow them.
And does this process involve medical practitioners?
It definitely can. So often if, as you said, if these red flags do present, then our typical advice to a client would be that they do need to engage with not only their GP but a specialist who can give evidence as to the person's capacity at that time to give us those instructions.
So it's really not necessarily good enough just to get a doctor's note from your GP saying, I think,
really.
Mary has capacity.
Yeah.
There's a bit more to it, isn't there?
And look, I mean, the important thing from our point of view is, as we are aware of this Banks and Goodfellow test, to be able to put that to a doctor in a letter is our preferred way of going about things. Because
it's a legal issue as well as a medical issue.
Exactly.
So we write to the doctor, preferably a specialist who practices in neurological issues or geriatricians or otherwise, and explain to them what the legal elements of testamentary capacity are, ask them to assess the patient and prepare a report. And that's going to be a lot more helpful to a court than just a letter saying they had capacity.
Definitely, yeah. I mean, we see that quite often where, somebody might already come with a GP letter and it is very short, and simply it won't be sufficient if that question ever does arise that they didn't have capacity.
And again, we talked about timing earlier. Obviously, you've got to have all your ducks in a row with this. There's no point in getting a report 12 months ago if it takes 12 months to see the patient again or see the client and get the document. So you've really got to be careful about the process on this.
Exactly. And look, our preference would be to firstly obtain the instructions from our client and then also factor those instructions into any letter that we prepare to the doctor to say, this is what our client is telling us. We need to understand and know that she can or he can appreciate the effect of the instructions that they're giving to us.
Okay. So you mentioned before red flags. What are some of the red flags that we would ordinarily look out for in these matters?
So as you mentioned, it might be an elderly client. It might be somebody who's suffering from a terminal illness and is on certain medication that may otherwise alter their capacity at any given time. Otherwise, cognitive decline, as you've mentioned. It could be trauma that the person has experienced recently, which has affected their decision making. It is often a good point for us to consider previous wills if this person is changing their wills quite regularly or rapidly and making quite extreme changes, and otherwise excluding close family members without any very clear or rational reasons behind doing that.
And we have a process that we follow. We would usually meet with the client by themselves. We don't necessarily want everyone in the room. We've got some people answering questions for the client. We like to ask open-ended questions and really do a detailed drill down into what our views are of their capacity, their ability to give us instructions.
And look, all of that is really important evidence at the end of the day, which is why keeping good file notes on these meetings is so important for us.
So what happens if capacity is challenged? So let's say that an executor goes to court and asks for a grant of probate of a will, and then a disgruntled family member or other person who might miss out under the latest will challenges capacity and puts on evidence before the court. There might have been a question about it. What happens then?
So at that point, the burden of proof shifts onto the propounder, so being the executor of the will. So they need to come about proving that the testator did have capacity at the time.
So they have to meet those elements of Banks and Goodfellow.
Exactly.
Then. And presumably then if they've seen a lawyer who understands the issues and has prepared the documents in a proper way, has obtained what medical evidence they can obtain to assist the court, that will make things a little bit more straightforward.
Absolutely.
As straightforward as litigation can be.
Exactly.
That will make things easier. Okay. So what happens if we've seen a client and we're not comfortable that they can give us coherent instructions, and we think there is a question of capacity about them, and there is a real need for them to have a will? These can be circumstances, people under profound disabilities who might own property already, and that might devolve in the wrong way. Is there anything that can be done?
Yeah, so an application can be made to the court for the court to essentially decide a will on behalf of a person, which is what's called a statutory will. So it is a complicated area of law, but however, it is something that we have experience in helping clients with doing.
Okay. So a big takeaway from this is, just because someone might be of extremely advanced age, or they might even have been diagnosed with a cognitive impairment, it doesn't necessarily mean that they don't have the legal ability to make a will, they don't have testamentary capacity. Is this an area that you see a lot that we practice in?
Yeah, there are cases coming out quite regularly. There's been a recent case coming out of the Court of Appeal in New South Wales, which found that the will maker, who did have Alzheimer's at the time that she prepared this will, which was later challenged, ultimately was held up to be valid, and that she had the testamentary capacity required to make that will. And a good
what did
quote,
the court say in that one?
And a quote that I like, the court said in that case, was that the law does not require that a testator be free from cognitive impairment, and it is simply that exact.
If you meet the test, you
exactly.
If the court's satisfied that you meet those Banks and Goodfellow tests, and that you knew and approved the contents of the will, then you have the right to have that
exactly
will recognised.
Absolutely, and ultimately it's a delicate area that needs to be handled with care by lawyers that have experience in this sort of field, which is why it is so important to get the right legal advice.
Excellent.
Great.
Thanks for your time, Ali.
That's okay.
Thank you. For more legal insights, subscribe or visit ballantyneLaw.com. We're here to help.